Welcome back to Ask a Lawyer. Next, we'll go to the city of Alachua, where attorney Rod Smith will be speaking to the Chamber of Commerce about employment law.
We have a Florida law, a federal law called the wage and hour law. I don't know where people come off, because I can tell you in my office, more employers call me and they say, you know, somebody just filed a wage and hour complaint against me that I wasn't paying somebody overtime. I don't have to pay them overtime, they're on commission. Well, you're wrong. There is a commission exemption. It is a very narrowly drawn exemption. And if you do not meet all three prongs of that test, then if you've had somebody out here working for a commission and they've been out there working 60 or 70 hours a week, and you think, well, I don't owe them anything, well, you're going to be in for a very rude awakening, because in fact you do. We also have a Florida law that identifies the minimum wage, which, as you know, is for some industries is a prevailing wage that has recently changed. We also have, and I've become, if I were a young lawyer today and I wanted to live in South Florida, God forbid, I told people what I practice. I practice immigration law. It is the new area that every employer is dealing with in the south part of the state. I tell you that because if you know how the state works, everything starts in the south and moves north. It will come here. It is not enough to say, I ask them for their papers. That is not going to get you off the hook when somebody comes in and says, and after 9/11, of course, the number of people who ask those questions has grown astronomically, and the interest in that has grown astronomically. A lot of people do not know this, some of you probably locally do, that actually one of the 9/11 individuals was working at a gas station in Williston, Florida, under false papers. It is a treacherous time for employers. It is a great time in one sense, and that is that we have probably in this community, and by this I mean Alachua, I moved here, when I moved here, Copeland Sausage about 3 years later shut down, and it was the #1 employer. And about 2 years later, GE, which was the #2 employer, cut its workforce by about 50% in a very, very short period of time. I think at one time they had almost 1,500 employees, and it went to 700 like that. It's a great time to be in this community. Despite what a few detractors would say, it's a tremendous time to be here. We have the greatest way to raise wages in the world is going on in Alachua, Florida right now. We got employers that are hiring more people, paying them better wages and benefits, and competing with other employers for employees. But for small businesses, the time is, you are now competing under the same rules that apply in the most instances to larger employers. Wage and hour, I hear people say, I don't think that applies to me. Wage and hour applies to you if you have 2 people. You and 2 will get you under wage and hour. Workers' comp is, I think it's you and 1 or you and 2 now, depending on how you classify your own employment. For all of the employment law provisions that have to do with the rights of women, the rights of minorities, the rights of national origin, and let me tell you, I hope that all of you know that what sounds funny when it's told as a joke at the workplace is not nearly as funny in front of a jury. And you need to tell your employees that. What you said, there is a company in Jacksonville that had a policy of allowing people to put up anything they wanted to put up in the bathroom walls. Well, apparently some of the male employees decided that they would put up what they wanted to put up, but they decided to put them up in the female bathroom walls. I think the judgment was in excess of $4 million. I'll just put this in the right perspective. I think Isaiah Thomas and Madison Square Garden just settled a lawsuit for $11 million was the settlement figure for one claim. I'm not suggesting that that will happen, but you are covered by that law if you have 15 or more employees for a small percentage of the year. And so I tell you these things. There is a law now called that we passed a few years ago that many of you will be dealing with, especially as your business. It's the Family Medical Leave Act. It is a highly misunderstood act. You have to have 50 employees, but it has to be within a 75-mile radius. So if you are with one of the branches that has 18 people in Alachua and 12 people in Gainesville and 40 people in Ocala, and it's within 75 miles by the natural traffic flow, you are covered by the Family Medical Leave Act. there are tremendous requirements under the Family Medical Leave Act of when you can let someone go and when you must allow someone. Someone said to me the other day, oh no, I don't have to apply with that, Rod. That has to do with when women are pregnant. Well, that has to do with when women are pregnant is one circumstance that it has to do with, but it's much, much more comprehensive than that. And the final thing that often connects with that is when someone now has the inability to do the job, but that inability may be based upon some physical disability that is a long-term malady that they have, you may very well have, and I will tell you, you probably have, a duty to try to accommodate that disability, or you may be answering saying, wait a minute, I didn't think they could do the job. Well, that isn't enough. And I tell you these things because they asked me to come out today and kind of forewarn as this community is growing. The businesses in this community are growing. And I could not be prouder. It is amazing for me to see this community. The businesses of this community are the life's blood of this community. But it is not as simple as people once thought about employment law, and that is, well, it's just between me and my employee. That's not true, because a person has a great deal of interest in their job now. This is a right-to-work state. That right to work means that you have the right to get rid of someone for good reason, bad reason, no reason at all, unless it is otherwise protected. And if it is otherwise protected, and I've already given you a series of examples, it is not, in the classic sense, right to work. People have rights that have the right to have those vindicated.